Hey guys, in this video, we're going to talk about harboring an illegal alien or an undocumented individual. Can you be convicted under federal law for harboring your spouse who sleeps in the same bed with you every day? Or can you be convicted if you're an employer and you hire illegal aliens? I'm going to break it down in this video, so watch all the way until the end. Harboring friends is a huge issue for the incoming Trump administration. We've heard Tom Homan, who is the incoming border and deportation czar, say things like, if you get in our way by harboring or concealing an illegal alien, you can be convicted of violating the federal law. What is this federal law exactly? Well, it comes right out of the INA, which is the Immigration and Nationality Act, and also 8 USC section 1324, which says that it is a crime punishable by a fine or imprisonment for any person who, knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law, conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shield from detection such alien in any place, including any building or by any means of transportation. What does this mean exactly? It's defined more specifically by the courts, and it really depends on which circuit you're located in. So, for example, in New York, under the Second Circuit Court of Appeals, harboring an undocumented individual is defined as conduct that substantially facilitates an immigrant's remaining in the United States illegally that prevents the authorities from detecting the individual's unlawful presence. There are two big requirements that must be met in order to be convicted of harboring as defined by the Second Circuit. You must have substantially facilitated, which also means making it easier for that individual to remain in the United States illegally. Or secondly, you must have done something that prevented law enforcement from detecting or finding that individual. Now, other circuits, like the Ninth Circuit Court of Appeals, defined harboring very differently, and in the Ninth Circuit, they define it as conduct that affords shelter to an undocumented individual. That's right. Merely sheltering them can get an individual convicted of this particular crime. Other shelters requires an affirmative action in addition to sheltering, and we're going to get into those examples momentarily. Now let's back up a little bit. In order for the government to be successful with their case against an individual, the government actually has to show four things. Number one, the government has to show that the alien entered or remained in the United States in violation of the law. Number two, the defendant concealed, harbored, or sheltered the alien in the United States. Number three, the defendant knew or recklessly disregarded that the alien entered or remained in the United States in violation of the law. And number four, the defendant's conduct tended to substantially facilitate, again, making it easier for the individual or alien to remain in the United States illegally. The penalties are actually quite severe under federal law. For the primary offenses of bringing in an unauthorized alien, an individual can face up to 1 year in prison. For bringing in that alien for purposes of financial gain, you can get up to 10 years in prison. For smuggling in an individual illegally, that's up to 10 years imprisonment. For transporting an alien illegally, up to 5 years in prison. For hiring 10 or more unauthorized aliens, up to 5 years in prison. If the unauthorized alien you helped cause serious bodily injury to someone else or endangered someone's life, well, that's up to 20 years in prison. Now, if violating this federal law results in someone's death, well, you can get up to life in prison. Now, I'm going to give you two examples of individuals in the Second Circuit Court of Appeals who were convicted of harboring illegal aliens. The first one comes out of U.S. versus Lopez. Mr. Lopez owned 6 homes in Long Island. His homes were considered a safe haven for undocumented immigrants. People knew while they were back in their home country, they knew that my destination is Lopez's home, one of those homes that Lopez owned. They would pay him $15 a week to stay there, and once they were there, he would help them with certain things like finding jobs, helping them with their job applications. He would drive them to and from work, and he also helped to arrange sham marriages so that they could get a green card. Obviously, Lopez was convicted of harboring illegal aliens because he knew they were there illegally, and he was helping them in a major way to be able to stay here illegally. The second case is U.S. versus Kim. Kim owned a garment manufacturing business. Kim hired illegal aliens to work for him. He not only hired them, but he also asked them to give him fake documents to show that they could work here in the United States legally, even though he knew that they were being investigated by federal authorities. He still kept them on the job, and he still used their fake documents to justify having them as employees. He was also convicted of harboring illegal aliens. Now let's talk about whether any of these acts would be considered harboring under the federal law. Number one, having a spouse in your home who is undocumented. Can you be convicted of harboring? Well, the answer is no in most circuits. Cohabitation alone by itself is not enough to convict someone of harboring. However, in some circuits, an argument can be made that sheltering that individual, your spouse, is considered harboring and a violation of the law. The Third and Seventh Circuits found that cohabitation alone is not enough to convict someone of harboring. However, in other circuits like the Ninth Circuit and the 11th Circuit, it is possible to make an argument that sheltering alone is enough to violate this law. What about renting a room to an undocumented individual? Can you be convicted of harboring? Most circuits say that merely renting an apartment or a space to an undocumented individual is not enough to convict the landlord or owner of harboring unless there is some additional affirmative actions that were taken by the landlord. If the landlord lies to ICE or tries to conceal that individual from law enforcement in certain circuits, well, yes, that landlord can be considered as harboring that individual and be convicted of this crime. More is usually needed in order to convict a landlord of harboring illegal aliens. What about an employer who hires an illegal alien? In most circuits, employers would also need to take more action or steps to conceal that individual from law enforcement. So, for example, if the employer knows that he has hired an illegal alien and has asked that individual to give him fake papers to show that this individual can work, or the employer is also providing housing, very low wages, or they fail to withhold federal taxes or report wages to the Social Security Administration, those acts, guys, can get an employer in trouble and be convicted under this harboring statute. What about immigration lawyers who provide legal advice to undocumented immigrants? Can they be convicted of harboring? Generally, no, they cannot be convicted of harboring, not unless they take some additional actions like create documents and submit fake documents to immigration so that an individual can get a green card, or they're also part of sham marriage arrangements, or they file these fake VAWA cases, fraudulent cases, and submit those cases to immigration. In those instances, yes, of course, the lawyer can be convicted for not only violating this law, but other laws as well. What about transporting or driving an illegal alien around? Well, in most circuits, you cannot be convicted of harboring for merely driving someone around. However, it really depends on the facts. If you know that this is an undocumented individual and you are being paid maybe by that individual to help that person remain in the United States illegally, including driving that person around for various purposes, well, it's possible to be convicted in some circuits for harboring. What about hiding someone from ICE? If ICE shows up to your home and they ask you, where is John Doe? And you know John Doe is in the basement of your home, and you lie and you say, I don't know, I don't even know a John Doe. ICE leaves and then later finds out that you lied to them. Well, yes, you can be convicted under this particular statute, in addition to, of course, obstruction of justice for getting in the way of a federal investigation. So you should never lie to ICE or any law enforcement official about about anything, but just always remember that you have the right to remain silent. Guys, harboring is a serious issue for the incoming Trump administration. Watch videos like this one. Continue to stay plugged in by subscribing to my channel and hitting that notification bell so that you'll be the first to get notice of these videos each week. I hope you found this helpful. Thanks so much for watching, and I will see you in the next one. Bye-bye.